Section 5 prescribes 5 conditions for solemnization of a marriage between two Hindus. Section 5 concerns itself with solemnization of marriage between two Hindus only. Both parties must be Hindus. Now we shall see the 5 conditions. The first condition is that neither party should have a spouse living at the time of marriage. This condition applies to both parties to the marriage. It requires that each party to the marriage should be either unmarried at the time when this marriage takes place, or if married earlier, then the earlier spouse must have expired, or the earlier marriage should have been dissolved or been declared void. This condition would be vitiated if the earlier marriage is still subsisting and the earlier spouse is still living. This condition is a manifestation of the policy of monogamy. A Hindu man cannot have two wives. A Hindu woman cannot have two husbands. The second condition is that at the time of the marriage, neither party must be incapable of giving a valid consent due to unsoundness of mind. Neither party must be suffering from mental disorder so as to be unfit for marriage and procreation of children, and neither party must have been subject to recurrent attacks of insanity. Here we are talking of unsoundness of mind, mental disorder, and attacks of insanity. This condition will not be satisfied in a case where either party to the marriage suffers from unsoundness of mind to such an extent that he or she is incapable of giving a valid consent. Similarly, if either party is suffering from a mental disorder which makes him or her to be unfit for marriage and procreation of children, this condition will not be fulfilled if either party to the marriage suffers from recurrent attacks of insanity at the time of the marriage. The third condition is that at the time of the marriage, the bridegroom should have completed the age of 21 years and the bride should have completed the age of 18 years. This condition will not be satisfied if the bridegroom is less than 21 years of age at the time of the marriage, or where the bride is of less than 18 years of age at the time of marriage. This is what is known as the minimum age of marriage. The minimum age of marriage for a man is 21 years. The minimum age for marriage for a woman is 18 years. The fourth condition is that the parties to the marriage must not be within degrees of prohibited relationship. This condition is relaxed where the custom or usage governing each of the parties permits such marriage within degrees of prohibited relationship. The fifth and the last condition is that the parties to the marriage must not be subpoenas of each other. Here also there is an exception. This condition need not be fulfilled where the custom or usage governing each of the parties permits a marriage of persons in subpoena relationship. For a marriage to be solemnized between two Hindus under the Hindu Marriage Act, parties to the marriage should not be subpoenas of each other, and parties to the marriage should not be within degrees of prohibited relationship. These are the 5 conditions which must be satisfied for a marriage under the Hindu Marriage Act between two Hindus. What is the effect and consequence if any of these conditions is not satisfied? Will the marriage be invalid if any of these conditions is not satisfied? No answer can be assumed to these questions at this stage. What Section 5 tells us is that for a valid marriage, these 5 conditions must be satisfied. However, it does not tell us as to what is the effect and consequence if any of these conditions is not satisfied. We will see that effect and consequence in subsequent sections of the Hindu Marriage Act. We would see subsequently that the marriage becomes void on non-fulfillment of some of these conditions. The marriage becomes voidable on violation of some other condition, and the marriage remains valid on violation of some of the conditions mentioned in Section 5. It is sufficient to say at this stage that the consequence of non-fulfillment of these conditions is different for different conditions. Section 7 tells us as to what rites and ceremonies are to be performed for solemnization of a Hindu marriage. Subsection 1 says, a Hindu marriage may be solemnized with customary rites and ceremonies of either party. Rites and ceremonies to be performed for solemnization of a marriage under the Hindu Marriage Act are not prescribed or specified under this Act. This section takes recourse to customary rites and ceremonies. Even though no statutory rites and ceremonies have been prescribed by the first subsection, the second subsection of Section 7 makes a statement of law. It applies where rites and ceremonies, or rather the customary rites and ceremonies, include saptapadi, that is, taking of 7 steps by the bridegroom and the bride jointly before sacred fire. As and where saptapadi is a part of the customary rites and ceremonies of either party, then the marriage becomes complete and binding when the 7th step is taken, that is, when the saptapadi is complete. Performance of the customary rites and ceremonies is absolutely essential for solemnization of a marriage under the Hindu Marriage Act as required by Section 7. I shall now illustrate the effect of non-performance of the customary rites and ceremonies through a Supreme Court judgment in Bhaurao Shankar Lokhande versus State of Maharashtra 1965. These are the facts of the case. Bhaurao Shankar Lokhande was married to complainant Indubai in about 1956. In this case, a complaint was filed by Indubai under Section 494 IPC. Indubai was married to Bhaurao Shankar Lokhande in the year 1956. She was his wife. Bhaurao Shankar Lokhande married again with Kamlabai in February 1962 during the lifetime of Indubai. Indubai filed a complaint under 494 and Bhaurao Lokhande was convicted under that section. Bhaurao filed an appeal before the Supreme Court and this was his contention. Essential ceremonies for a valid marriage were not performed during the proceedings which took place when Bhaurao Shankar Lokhande and Kamlabai married each other. This has a reference to the second marriage of Bhaurao Shankar Lokhande. It was further contended by Bhaurao that in law it was necessary for the prosecution to establish that the alleged second marriage of Bhaurao Shankar Lokhande with Kamlabai in 1962 had been duly performed in accordance with the religious rites applicable to the form of marriage gone through. It was the prosecution's contention that Bhaurao had married Kamlabai in 1962 during the lifetime of Indubai. Since it was the prosecution which contended the existence or validity of this marriage, it was for the prosecution to establish that this second marriage or the alleged second marriage was duly performed in accordance with the religious rites applicable to the parties. We shall now see the law laid down by the Supreme Court in this judgment. This is what the court said. If the marriage which took place between Bhaurao and Kamlabai in February 1962 cannot be said to be solemnized, that marriage will not be void by virtue of Section 17 of the Act and Section 494 IPC will not apply to such parties to the marriage as had a spouse living. It was therefore essential for the purpose of Section 17 of HMA that the marriage to which Section 494 IPC applies on account of the provisions of the Act should have been celebrated with proper ceremonies and in due form. Merely going through certain ceremonies with the intention that the parties be taken to be married will not make them ceremonies prescribed by law or approved by any established custom. The Supreme Court thereafter applied this law to the facts of this case in the following way. The court said that the second marriage was not performed in accordance with the essential requirements for a valid marriage under Hindu law. On this finding, the court concluded as under. Therefore, the marriage between Bhavu Rao and Kamlabai does not come within the expression solemnized marriage occurring in section 17 of the Act and consequently does not come within the mischief of section 494 IPC, even though the first wife of Bhavu Rao was living when he married Kamlabai in February 1962. We can thus see the importance of the performance of customary rites and ceremonies for solemnization of a marriage under the Hindu Marriage Act.